Funding for Idaho Reports is provided by the Friends of 4, 10, and 12, the Corporation for Public Broadcasting, and by a grant from the Laura Moore Cunningham Foundation.
If you reprimand me, you may also harm yourselves. You make it possible for you to become the victim of a similar nightmare. I strongly urge you to reject the recommendation of the committee, and let's get back to fairness and ethics.
Rejecting his impassioned defense, the House votes overwhelmingly to reprimand Idaho Republican Congressman George Hansen. Good evening. Congressman George Hansen steadfastly maintained his innocence today, but his colleagues in the United States Congress voted 354 to 52 to formally reprimand the Idaho Republican for failing to report several financial transactions on his personal financial disclosure form. The reprimand is the lightest punishment allowed under House rules, and while it was clearly a rejection by the House of Hansen's case, it carries no other formal sanction. The House today affirmed the ruling of its Ethics Committee, which had voted that Hansen had filed improper disclosure forms. Hansen has also been convicted in federal court on 4 felony charges in connection with the same case. Hansen's remarks in the House today were emotional, and again today he said his financial report was really no different than the report filed by Democratic vice presidential candidate Geraldine Ferrero. Tonight we have extensive excerpts of the House debate today, and later some reaction from Hansen's Democratic opponent. The principal case against the congressman was presented today by the chairman of the House Ethics Committee, Congressman Louis Stokes of Ohio.
There simply is no support for Mr. Hansen's claim that he did not have to report the loans because the funds were to be directed elsewhere. If his theory was right, very few transactions would be reportable, because members could serve as conduits for various entities and get around the clear intent of the law. Mr. Hansen stated that he confirmed his interpretation regarding the $135,000 with his staff attorney. He did not go to his Idaho attorney on this one. The staff attorney, however, admitted that when he gave Mr. Hansen the answer he had requested, he did not know about the Dallas loan, the silver profit, the nature of actions Mr. Hansen took on behalf of the Virginians, or other important facts. Again, this withholding of information by Mr. Hansen to his attorney undercuts the advice he allegedly was given. Mr. Speaker and members of the House, the committee studied these facts and carefully looked into the transactions involved and concluded that Mr. Hansen's omissions were not inadvertent. The nature of the transactions was such that Mr. Hansen had good reason not to want them to become public. Remember that Mr. Hansen reported nothing about the existence of these debts and profits. He did not claim the spousal exemption. This failure to make any reference whatsoever supports the view that he simply did not want these transactions known. Moreover, even if Mr. Hansen's theory about the transactions being his wife's was believed, this theory would not explain why he failed to report the $135,000 Virginia loans, which are transactions in which his wife were not involved. On the basis of the evidence at the trial, as reviewed by the committee adopted a resolution finding that Mr. Hansen's conduct violated 4 rules of the House. Rule 44 on financial disclosure, Rule 43, Clause 7 for undertaking his direct mail campaign despite the committee's opinion, Rule 43, Clause 4 for accepting gifts from persons with interest in legislation, Rule 43, Clause 1 for failing to reflect credibly on the House, and the Code of Ethics for Government Service for accepting things of value under circumstances which easily could be construed as being improperly given or received. After the adoption of this resolution, Mr. Hansen and his counsel were given another opportunity to address the committee during the second phase of the inquiry. Again, Mr. Hansen and his attorney testified and made submissions following the session and the advice of special counsel. the committee voted to recommend to the House reprimand. This report then is what is before you today. I urge the adoption of the resolution, and I reserve the balance of my time.
South Carolina Republican Floyd Spence, a member of the House Ethics Committee since 1971, joined Stokes in making the case against Hansen. Spence saying both Democrats and Republicans had examined Hansen's record, and the record supported a reprimand.
Just let me say that we have agonized over this matter from all sides, from every viewpoint. I firmly believe that we have considered all the questions which have arisen or may arise in your minds or which may be brought up during debate on this resolution. Our recommendation is a bipartisan consensus product of our deliberation. No one regrets more than I the need to bring this matter before the House. As I've noted, we take no pleasure in carrying out our responsibilities under the Constitution, but we have no other choice. Not only must we discipline ourselves, Mr. Speaker, more importantly, we have to assure the people of this nation that we are capable of policing our own house. The matter before us today is not restricted to the case of an individual. In reality, it affects every member of this body because it reflects on the integrity of our system of government. If the people of America lose faith in us and our willingness to deal with unpleasant situations, they will also lose faith in our ability to govern. Mr. Speaker, we of your committee have struggled for several months with the issues in this case. We have considered thoroughly the relevant rules of the House, Representative Hansen's defenses to his failure to abide by those rules, and the punishment which is appropriate. I am convinced that we have reached a correct and a just result, and I urge our members to support the committee's resolution.
Hansen spoke in his own defense for about 35 minutes. Here is some of what he said.
Now, I think it's very important to know that, for you to know, that I hardly recognized myself from what the chairman gave in his statement of facts, and I say so-called facts, in the well a moment ago. And I don't know who prepared the statement, but I would have to take strong issue that any resemblance of these facts to the truth, in most cases, is purely coincidental. I can tell you first that despite what was said in some of the trial record, that I did not initiate a conversation with Nelson Bunker Hunt for money. And I get tired of hearing the story. And the thing that interests me is the way the special counsel has insisted on playing prosecutor worse than the prosecutors that I had downtown. And they bring all the trashing up that really, in many cases, is irrelevant to the facts. The facts are, did I include these things on the record? Not all of the rest of the exercise. And I have freely admitted all along that I did not include them on the record for good cause. Now, they say something about the fact that my wife should have been maybe in the process of divorcing me so that I could utilize the division of property arrangement that we had. That's a little bit like Washington, D.C. in general. It seems like all they have to do is break up families. And it seems that you can't make an arrangement between you otherwise. And I found that this was the case in the court, that it would have been all right if my wife and I had gotten divorced and then just cohabited or something like this. But don't you try to stay together and work out your problems. We were saddled with a debt, Mr. Speaker. We were saddled with a debt brought on by an encounter with an erstwhile colleague, Wayne Hayes, years ago, and it was a pretty bloody political encounter. And it cost a lot of money. And I had the opposing party chairman in my state and district take my credit report improperly, and we fought for several years and ran up a huge debt. And then the Ethics Committee decided to shut the door on any kind of a way, it had been open before until George Hansen walked in, on any way to try to retrieve some kind of ability to pay for that debt. Now, there are those who have run up large debts. And I remember a former colleague of ours, Hubert Humphrey, got into a serious debt problem, and he finally settled out so many cents on the dollar. Well, some people have to do that or feel that's the way to go. I've tried to hang on to that debt and pay it honorably. And this is what I end up with for trying to do it. We didn't make an arrangement to try to get around the rules of the House. We tried to make an arrangement to accommodate to the rules of the House, and we ask and we ask and we ask. And the record is replete with the askings that we made. And it gets a little tiresome to have someone stand and say that George Hansen never came and leveled with the committee, because that's poppycock and the paper trail is a mile long. And I think it's high time that some people recognize what's there. I passed out a piece of paper around here today that lays out excerpts from letters time and again through the period of time in question, 1978 particularly, when we were in the formative stages of Rule 44, that lays out what the people involved were saying at the time, and time after time they say there is no reason to bring action, you acted in good faith. And the one thing that the committee has actually, I don't know if it's intentionally or not, but refused to look at is what these three spouse situations are. There are three transactions that my wife took care of independently of me, absolutely independently, to the point of having a co-signer independently of me, at a time when we had a property settlement agreement that divided our property. And to get up and say that that property settlement agreement has never been operative is absolute poppycock. There was nothing said that you couldn't have joint accounts and joint ownership after you had a property settlement agreement, and that's a contamination of what the whole case is about. And it's a refusal to understand. Under the spouse disclosal situation, it's stated time and again that you can have this type of situation if you absolutely are totally separate. And these were separate transactions. Nothing that I transferred to her. And the document that they keep bringing up about this special draft advisory document, it kept talking about transfers. There were no transfers. We're talking about something else. We're talking about assignments, but that isn't even the case on these three. We're talking about three transactions that were hers totally, first, last, and always. And it was not my business to disclose. And the committee knew it, and the committee has signed off on it time after time. Now, if they had a draft, went to the bother of having a draft advisory document in their files, why didn't they send it? There was a letter that was covering it that didn't go out either, that says that we will have a final document to you in 2 weeks. The document didn't come, and I challenged the committee to show me where the final document is if they sent it on a final basis. It didn't come. We were never advised that we couldn't do these things. We always had a green light. Once in a while it flashed on caution. They contrived once to put up a red light. They put the special advisory together, and they thought they were blocking us, and they found out they were talking up the wrong channel. And it didn't work, and they put it in the file, and they didn't send it. And our former Congressman friend Charles Wiggins has stated in affidavits and otherwise that there are reasons why it wasn't sent, and those reasons are commensurate with my case. Now, this business of talking about Rule 44 and Rule 43 and all the paragraphs and everything else, that's a bunch of baloney. That was a trashing up operation, as far as I'm concerned, courtesy of the Justice Department, that the special counsel just didn't weed out. They couldn't resist using it. And it was thrown out, as the members of the committee know, and we got down to the one thing we're here for today, and that's to talk about Rule 44 and whether I disclosed on spouse disclosal or not. And let me tell you this much, that I'm not the only one that has the problem. And I'm not the only one that should be standing here, because there are a number of people in this body and throughout the government who are filing ethics reports that ought to be filing differently if I'm supposed to be standing here, or they ought to be here with me. And one of them is the counselor to the President of the United States, who had the same problem, a spouse disclosure problem, where it was admitted that he apparently forgot. The Attorney General of the United States, it wasn't spouse disclosure, but the Attorney General, the boss of the prosecutors, he had a $50,000 severance pay when he came into government. He didn't put it on his ethics report. They called him in and counseled him. He put it down, and everything was hunky-dory from there on. Everybody else gets to amend. But old Lonesome George gets to pay the price, and I'm getting darn tired of it. Now, I'm no different than a lot of the rest of you. All I am is the precedent for some of you. And if I were you, I'd be very, very careful about how you vote today. We have a colleague here that's taken a lot of abuse in the press the last few days. She's now vice presidential designate for, or candidate for the other party. And I'm not here to call any wrath down on anyone. I wouldn't do that. I've gone through enough hell myself without calling it on somebody else. But if you do something like this to George Hansen today, are you going to call her in tomorrow? You're going to call the wrath down on Mr. Meese? You're going to call the wrath down on the others who omitted spouse disclosure on their forms? What are we going to do about having some kind of uniformity in ethics around here? Or are we going to do it in a selective way? I advised the Standards Committee in answer to one member's questions that even though I believed that I had acted lawfully in not reporting my wife's debts and silver profit, I would be prepared today to amend my forms for the years 1979 through 1982 to reflect the items which I am charged with having omitted. That's never been a problem. If any of you know, I remember how you fill out your forms, it would have been one more bank on the list of banks that you have. Who worried about filling that out? Who was trying to hide it? Not me, Mr. Chairman. Not me, Mr. Speaker. But I am not given the same courtesy that was given to Mr. William French Smith, Mr. Edwin Meese, or Mrs. Geraldine Ferraro. This entire experience is unreal to me. It's fitting in a sense that it take place in 1984, the year that has come to have a literary significance because of George Orwell's great novel, as a year when injustice can triumph, when some people can become more equal than others, and when government by Big Brother takes over the world. Or to use another literary comparison, what has happened to me is Kafkaesque. I view myself as a victim of a horrendously unfair process. I was the victim of a totally false and defamatory blackmail effort. And instead of being treated as a victim, I became the accused. And I can tell you some real horror stories about the way your Justice Department acts in that type of situation. I've had my penalties, and I've done it right. And I've done it with advice, not just of my attorneys, but the advice of counsel. And there's one thing more important to me than anything else. It's my good name. And I don't appreciate the smirching of my name in these cheap shots, because we did it right and the track record is inches high. If that isn't enough, who is safe in this paperwork jungle that we live in? Because each and every one of us sign forms every day, your tax forms or whatever, that some agent of the government could arbitrarily take you to task over, and we'd better put a stop to it before everyone in this country is a walking felon. Now, you can understand why I think this must be a terrible nightmare. If you reprimand me, you may also harm yourselves. You make it possible for you to become the victim of a similar nightmare. I strongly urge you to reject the recommendation of the committee, and let's get back to fairness and ethics. I reserve the balance of my time, Mr. Speaker.
But another Republican member of the Ethics Committee specifically contradicted one of Hansen's principal contentions.
He has pointed out a series of examples of people who have filed forms and later found they needed to amend them. Perhaps drawing an analogy between those folks who filed forms and had to amend them and himself. The point I'd like to make for the body is this. We are not dealing with a situation where a form has been filed and later amended. We are dealing with a situation where a form has been filed, where the committee has made clear that that filing is not adequate, and that even at this late date, 5 weeks after the conversation I just related in the formal testimony, even at this late date, a correction or amended form has not been filed. In other words, the question we have to face is not whether or not there's a confusion about the filing requirement, but whether or not indeed the filing requirement is going to be complied with. To fail to take action under these circumstances, it seems to me, leaves the House in the position of refusing to enforce the rule.
The matter of the Virginia loans, the loans of $135,000 from 3 Virginia men, a substantial amount of money. When you consider at that time that was more than twice the salary, annual salary of a congressman. Nowhere was that reported. That was not his wife's business. It was not reported because he was a conduit for a committee that he was a part of to try to change the tax laws of this country. That was never the intent when our law was enacted to require reporting. If it was, any one of us that wanted to engage in an action, all we would have to do is to set up a committee and act as a conduit and go and get loans. I don't think that was ever intended.
Texas Republican Ron Paul was one of 42 Republicans to vote against the reprimand.
Quite frankly, I believe in my own heart that they're victimizing Mr. Hansen. They've made him a target. They're making him an example. I think that's sad. Whether I'm right or wrong doesn't matter. I think it's sad that I believe it. I actually really believe that I could be victimized by coming down here and standing up. I really believe that, and that says something about our system. I can't prove that, but the fact that I believe it means there's something wrong with the system. I'm not going to vote to reprimand Mr. Hansen. I think a lot of others shouldn't vote either. And I think if you have the slightest doubt in your mind, if you one day want to not vote as a hypocrite, vote present or do something. But this is a con game as far as I'm concerned. I think Mr. Hansen has given a credible and a sincere attempt. He's given a credible argument. He's made a sincere attempt to put the records out. A lot more than I ever believed was going on from reading the newspapers. I mean, there's a lot of records to this. Quite frankly, I can't sort it all out. I don't know all the details and whether there has been a technical violation or not. But quite frankly, I think the spirit of the law and the spirit of the rule was not intended to do what we're doing here today. Thank you.
Again, the vote on the Hansen reprimand in the House today was 354 in favor, 52 opposed. Hansen's Democratic challenger, Richard Stallings of Rexburg, held a news conference in Boise late today where reporters wanted to know his reaction.
I think Congress has spoken for itself. I think that the idea was that justice was more important than partisan politics has been borne out. That you had about 70% of the Republicans that were voted for the reprimand. Obviously, the Democrats, strong majority of them voted for the reprimand, and so I think that they were trying to clean their own shop. And I think that is something that had to be done. The integrity of Congress, I think, was at stake.
They had the option of doing more than a reprimand. Do you think they should have done more censure, possibly?
Well, that's hard to say. I've not seen all the evidence. I've not seen the files of information that was compiled, and for me to judge from Boise is a little tough to do. I would think that they probably did what they felt was fair. The Ethics Committee is made up of 6 Democrats and 6 Republicans. They looked at the evidence, they tried to put partisanship behind them, and they made their decision. I think it was probably just in light of what I know.
Idaho's other Congressman, Larry Craig, did not vote today. Craig saying it would be improper for him to take a stand on the issue because he works so closely with Hansen all the time. Craig saying any judge so closely involved in such a matter would have to disqualify himself. Craig's Democratic opponent, Bill Heller of Coeur d'Alene, says Craig's refusal to vote today shows his, quote, arrogance. Heller says, and I quote, George is unethical. Craig says he can't vote because George is his friend. Ethics ought to transcend friendship, end quote. The political impact of this now with a reporter who's been following George Hansen's political career for a long time. And last on this broadcast, Randy Staples was the editorial page editor of the Idaho State Journal in Pocatello. He has since moved to Boise and joined the news staff of the Idaho Statesman. Randy, Senator James McClure said today that he thought this would have little effect on Hansen's situation, primarily his election chances, since it was so expected and it was a foregone conclusion that was going to happen. Do you read it that way?
Well, Mark, it's a little bit hard to say. I think the election is going to be very close, so it may have an impact. I don't think this will wind up changing very many votes in that sense. So I think he may have been correct up to that point. But when an election is this close, every vote that's chipped away from one side to the other is going to make a difference, and this isn't going to help the congressman.
And this, I take it, you would see this as just a continual chipping away at that support that he has.
It's one more thing that weakens him a little bit, not by itself a great deal, but it weakens him.
Is it your sense, Randy, now that most people who have, because this has been in the news for so much for so long, that most people who have thought one way or another about this race have made up their minds?
I think so. I think most people in the district probably made up their minds about Hansen some years ago. I think the percentage of people that, the percentage of the swing vote has been gradually eroding, especially over this last year as Hansen has become increasingly high profile, as things have been coming to a head. And I think that'll continue to happen over the next few months.
This action by the House coming here today on the last day of July, that leaves August, September, and October before the November election. This is likely to be the last harsh thing to happen to George Hansen. There'll be no resolution of his appeal on his felony convictions. Does that give him enough time to repair the damage a little bit?
Well, it's probably downhill from here, in a sense. Hansen, I'm sure, will use this remaining time to come back to the district to try to talk to small groups of people, individuals, key individuals all around the district. And if nothing else happens, it'll be a much more favorable thing for him. This should be a relatively good time for him now.
Does this really lopsided vote in the House today, does that surprise you at all?
Not greatly once the Ethics Committee makes up its mind, especially on very complicated matters like this. I think the House tends to go along with it.
There's an implication in some of the things that the Congressman said today that many members probably didn't understand what they were doing today, didn't understand the details, and even Congressman Paul there a moment ago on the videotape, a supporter of the Congressman's position, said he didn't understand all that was going on. Is that a fair assessment, that most people probably didn't know the details of this?
I think that's probably true. It is a very complicated thing. It's a case that goes back quite a number of years. There are a number of financial transactions involved, there are a number of legal principles involved, and it would probably be unfair to expect that every congressman would understand all the details of this case. And that's why I would expect that many of them would simply take the advice of the committee that had been looking into it for a longer time.
Let me just ask you quickly about this Geraldine Ferrero connection that the Congressman has made a good deal of in the last few days. Can that be made to stick, that his case is not dissimilar from hers?
Well, there are some differences between the two cases. There are differences in the kinds of contributions that were made, and a large part of it had to do with campaign contributions that were made that were not entirely proper. So there are some differences between this case and some of the others.
Let me ask you finally, Randy, about Larry Craig's not voting today. Do you think that'll hurt him?
I think he could probably make a reasonable case to people that he could not be an impartial judge the way many congressmen would be, because there are only 2 congressmen from Idaho and he has to work naturally so closely with Hansen. I don't think that'll probably wind up hurting him a great deal.
Well, Randy Staples, thank you for being with us tonight. We appreciate it very much. That's our time for tonight. We'll be back tomorrow. I'm Mark Johnson. Good night.
Funding for Idaho Reports is provided by the Friends of 4, 10, and 12, the Corporation for Public Broadcasting, and by a grant from the Laura Moore Cunningham Foundation.